My name is Eliza Mugabo. I am a candidate attorney in the Competition Department in our Cape Town office. Today I will be discussing the Competition Act of Botswana. As competition legislation continues to grow and take shape on the African continent, it has become imperative for companies notifying proposed mergers in South Africa to gain knowledge of competition law in other African countries where they may hold subsidiaries, as they may be required to notify in these respective jurisdictions. This presentation focuses on Botswana, which for some time has not had a competition regime in place. The Competition Act of Botswana was enacted in 2009 to regulate competition in the country's economy. Only parts 1 to 4 of the Act are currently in effect. These are the parts which establish the authorities that will enforce the legislation. The Act establishes the Competition Authority and the Competition Commission, which is the governing body of that authority. Decisions of the Commission may be taken on appeal to the High Court. Part 10 of the Act provides specifically for mergers and acquisitions. The Act provides for the mandatory notification of mergers meeting asset and turnover thresholds prescribed by the Minister. At present, these thresholds have not been promulgated yet. In assessing a proposed merger, the authority must consider whether the merger would be likely to, firstly, prevent or substantially lessen competition, restrict trade of the provision of any service, endanger the continuity of supplies or services, or finally, result in any enterprise acquiring a dominant position in the market. The authority may also take into account any factors which it considers relevant to public interest. The authority may grant approval subject to conditions. The authority may revoke a decision to grant approval if the decision was based on materially incorrect or misleading information, or if the condition attached to the granting of the approval is not complied with.